Anatomy public case Emrest against the CIA. The III discovery against the CIA. Unlike other litigants, the CIA has an almost unlimited capacity to conceal probative evidence and to assert privileges against disclosure with little judicial intervention. In the Canadian brainwashing case, getting the truth about what happened was all the more difficult because 2 decades of concealment were continued into the 1980s with unwarranted claims of national security privilege. Nonetheless, the discovery and trial preparation process did yield new evidence further demonstrating the CIA's negligence in the MKULTRA program in general and in the Montreal Experiments in particular. 8. CIA concealment of the facts. 5 means of concealing the truth hindered our investigation of the CIA's negligence. Documentary evidence about MKULTRA was destroyed. The details of the MKULTRA program were restricted to a handful of CIA employees. Witnesses who did know about MKULTRA were prevented from testifying. Witnesses who did testify told as little as possible, and national security claims were groundlessly invoked to prevent disclosure of information embarrassing to the CIA. Oliver North was not the government's first shredder. Most of the documentary evidence about the Montreal Experiments had been destroyed in 1973. At that time, CIA Director Richard Helms and Sidney Gottlieb, who were both planning to leave the agency, joined in ordering the destruction of all MKULTRA files. 21 This loss was particularly significant because it denied us a documentary basis for cross-examining Mr. Helms, whose lack of credibility had been established when he committed perjury in testimony before Congress in the mid-1970s. In the early 1970s, Helms categorically denied under oath before the Senate Foreign Relations Committee that the CIA was trying to overthrow the Marxist Allende government in Chile, when he had, in fact, directed massive covert efforts to do just that. 22 Moreover, Helms went out of his way to lie. For the false testimony came not at some Senate hearing where he was defending the CIA's reputation, but at a hearing where he was personally seeking confirmation as ambassador to Iran. The honorable course would have been to refuse to discuss the Chilean incident with the committee and to take his chance of losing the ambassadorship. It was not any secrecy that Helms had with the CIA that was at stake. It was his nomination as ambassador to Iran. Faced with the alternatives, Helms lied. Although this was clearly perjury, when angry senators forced the prosecution, the Washington establishment rallied around Helms, who was allowed to escape justice by pleading to a single violation of 2 U.S.C. Section 192, a statute that requires witnesses to answer questions before Congress. This was the sweetheart deal Helms got. In order to relieve Mr. Helms of pleading to a felony charge of perjury, the Justice Department created a special misdemeanor to which he was permitted to plead no contest. The Department of Justice charged Helms with, Helms pleaded to, and the judge sentenced him for the crime that doesn't exist. The Department of Justice was so anxious to strike a bargain with the defense that it manufactured a crime for the occasion. Mr. Helms was charged with the misdemeanor of failing to testify fully, completely and accurately before a Senate committee. There is no such crime. There is a felony statute of perjury before Congress and a misdemeanor statute of contempt of Congress or a refusal to answer. Helms was charged under the latter statute. But he did the exact opposite. He did not refuse to answer, he answered and did so falsely. This is not a crime under the refusal to answer contempt misdemeanor statute. Yielding to the government's intense pressure to accept the no-jail plea bargain, Judge Barrington Parker assessed only the $2,000. The group of 400 retired CIA intelligence officers promptly donated funds to pay Helms' fine at an impromptu victory party at the Kentwood Country Club following his sentence. 23 As Joseph Raw wrote in the November 9, 1977 edition of the Washington Post, the CIA now knows that the law is only peripherally for them. The problem that Helms presented was typical of those we would face with the covert operators at the CIA. Here was a man who had lied to Congress and gotten away with it. Was there any reason to expect him to do less in a private litigation? The 1973 destruction of MKULTRA documents virtually guaranteed that Helms would have free rein to concoct any story at all when we questioned him. As the Helms perjury incident demonstrates, Senior CIA officials can seemingly lie with impunity, and documentary evidence is therefore all the more critical in getting the truth. The lost documents would also have been a great aid in questioning Sidney Gottlieb, who had earlier demanded immunity from prosecution before testifying about his role in CIA assassination plots, including one in which he had personally carried anthrax toxins to the Congo in an abortive effort to eliminate the trace legume. Without documents to force their testimony, Helms and Gottlieb would be free to forget and thus to evade whatever they wished. 24. To conceal further its role in brainwashing experimentation, in the early 1950s the CIA established a front organization, the Society for the Investigation of Human Ecology, sometimes abbreviated SIHE, at the Cornell University Medical School in New York City. As CIA officer John Gitter confirmed, the society served as a conduit for brainwashing research. Since the program operated undercover, people outside the CIA were prevented from knowing anything about MKULTRA. There would be no witnesses outside the agency. The MKULTRA program also operated outside the normal CIA administrative channels without the usual contractual arrangements, and was concealed even inside the CIA under a practice called compartmentation. As the more recent CIA director, Stanfield Turner, explained at his deposition, in MKULTRA CIA employees used compartmentation to so narrow who knows a thing, that there was virtually no check or very little check on their activities. Compartmentation thus ensured that there would be no witnesses aside from Helms, Gottlieb, and their assistants. 25. When former CIA employees were subpoenaed and did testify, lawyers for the agency prevented full answers to our questions. This practice took the form of rather blatant intimidation. For example, at a meeting to prepare his testimony one day prior to deposition, John Gitter was told by counsel for the CIA that he would be liable for prosecution if he began to talk about some of that. Furthermore, although the CIA counsel present at the deposition did not represent Gitter and would have had a conflict of interest had he done so, he nonetheless directed Gitter not to answer a number of questions, a practice authorized neither by statute nor rule of the court. In subsequent depositions, CIA lawyers simply ignored their conflicts of interest and claimed to represent both the CIA and its former employees. Then they decided that a question should not be answered. In this way, even the former employee who wanted to tell all could be prevented from doing so. The testimony that we did obtain from former CIA officials was often less than candid. The central axiom of clandestine activities, such as the MKULTRA program, is that CIA must maintain plausible deniability. This means that layer upon layer of cover stories are available to conceal agency involvement, and that agency operatives are schooled in telling half-truths or outright lies to minimize disclosures. There were many examples of this practice in the revelations of MKULTRA. CIA agent James Monroe erroneously told the New York Times that the Society for the Investigation of Human Ecology, which he ran, received only 25 to 30% of its budget from the CIA, with the bulk coming from other foundations and private donors. The truth is that over 95% of the Society's funds came from the CIA. When that cover story failed and the Canadian victims presented their claims, efforts to minimize CIA responsibility included a completely inaccurate claim to the Canadian government and plaintiffs' counsel that Dr. Cameron applied for funds unsolicited. 26. Against this backdrop of institutionalized lying, we were never sure that we had gotten everything that the witness knew. Finally, throughout the litigation, the CIA repeated ignoring its claim of secret intelligence sources and methods to keep us from uncovering the full facts. While it is difficult to understand how information concerning a program that ended some 20 or more years ago could threaten our national security, it is easy to see how the broad sources and methods privilege ratified by the Supreme Court in CIA v. Sims 27 could be exploited to hide evidence of CIA wrongdoing. The pernicious Sims doctrine is particularly damaging, because the vast majority of secret material is classified not to protect our security, but to prevent official embarrassment. And, even where there was some legitimate security concern in the beginning, the privilege continues to be asserted many years later when there is no need for secrecy. The prevalence of the assertion of national security privileges to avoid political embarrassment by the intelligence community was documented in a column by former Solicitor General Erwin Griswold. 28 as Dean Griswold recounts from his experience when representing the Nixon administration during its unsuccessful effort to prevent publication of the Pentagon Papers: 29. It quickly becomes apparent to any person who has considerable experience with classified material that there is massive overclassification and that the principal concern of the classifiers is not with national security, but rather with governmental embarrassment of one sort or the another. There might be some basis for classification while plans are being made, or negotiations are going on, but apart from details of weapons systems, there is very rarely any real risk to current national security from the publication of facts relating to transactions in the past, even the fairly recent past. Under this fallacious national security rubric, as expanded and ratified by the Berger Court's since decision, identities of key witnesses were concealed from us, documents were withheld, and on one occasion we were personally threatened with prosecution under the Espionage Act if we did not agree to excise information from the deposition of Richard Helms. 30 Most importantly, as we detail below, even though the two CIA station chiefs in Canada in August 1977, Stacey B. Hulse and John Kenneth Noss, had been publicly identified as such, we were prevented from obtaining their deposition testimony concerning their briefings by the CIA on the Cameron experiments and what they told the Canadian government on the agency's behalf when the story broke in Canada. The additional facts from discovery and trial preparation underscore CIA negligence. Despite the unique problems in conducting discovery against the CIA, we were able to obtain important new evidence of the agency's negligence in each of the three facets of the case. The story of the Olsen death, and the CIA's eventual acceptance of responsibility in 1975 was even more compelling when recounted by his widow, whom we eventually hoped to use as our first witness at trial. The CIA's negligence in funding Cameron, the reckless loose cannon, was confirmed by his contemporaries in Montreal. The CIA's negligence in failing to ensure the safety and consent of Cameron's patients was admitted in deposition testimony by CIA officers. The group of psychiatrists who evaluated our client's experiences under Cameron's care confirmed the bizarre and injurious nature of the CIA-funded brainwashing experiments. Finally, during discovery we had obtained important admissions of culpability on the part of the CIA and the U.S. government. 1. New evidence about the Olsen death. One of the most courageous people to join in this fight was the widow of Dr. Frank Olsen, Alice W. Olsen. Despite the pain and anguish caused to her by recounting the details of the tragic CIA experiment upon her husband, Mrs. Olsen agreed to appear as a witness for the plaintiffs and was prepared to offer testimony concerning her husband's death. As Mrs. Olsen explained in her affidavit to the court, in 1953 my husband was a distinguished biochemist working as a civilian employee of the United States Army at Camp Detrick, Maryland. My husband and 3 of his colleagues were given LSD, without warning, by CIA officials Sidney Gottlieb, chief of CIA's TSS Chemical Division, and his deputy, Robert Lashbrook. As part of the CIA experimental brainwashing program designated as MKULTRA and operating under the direction of Richard Helms, chief of staff of CIA's clandestine services, Gottlieb and Lashbrook fed the LSD to my husband and the others in their after-dinner liquor without telling them that there was LSD in the Cointreau glass, nor that they were the subject of CIA experiments. Mrs. Olsen next describes the negligent and reckless behavior of Gottlieb and Lashbrook after the injurious effects of that LSD experiment became apparent. When Frank came home on the Saturday following the CIA experiment, he was uncharacteristically moody and depressed. He was in great distress and in obvious need of help. But, instead of being taken to a psychiatrist in Washington or Maryland, Gottlieb and Lashbrook took him to an allergist in New York City, Dr. Harold Abramson, who was working with the CIA on its LSD experiments. Frank had 2 sessions with Abramson. After the first session he returned to this area, but when he got as far as Bethesda, he told me on the telephone that he was afraid to return home because he might do something wrong in front of the children. So he and Lashbrook returned to New York for a second session with Abramson. That night he jumped from a window of a 10th-story hotel room in New York in which he was staying with Lashbrook. Finally, Mrs. Olsen explained the direct link between the LSD and her husband's death. My husband was a remarkably stable man. He had never had any psychiatric problems before he was fed the LSD in 1953. As President Ford put it when he signed legislation in 1975 providing $750,000 recompense to our family, the CIA's drug experiments were the proximate cause of his death. There is no doubt that CIA-administered LSD is what caused Frank's death. Mrs. Golson's personal recollections of the tragedy would not only underscore the magnitude of the negligence and incompetence of CIA officers Cutler and Lashbrook, but would also show the court that the government had already accepted responsibility for their misdeeds. There were even public admissions of responsibility from the highest levels of our government that Mrs. Olson could describe in court. When the Olson story finally became known despite the CIA's efforts at concealment, then President Gerald Ford met with Mrs. Olson and her children on July 21, 1975 and, according to a White House press release, expressed the sympathy of the American people and apologized on behalf of the U.S. government for the circumstances of Dr. Frank Golson's death in November 1953, and in a July 24, 1975 letter to Mrs. Olson, then CIA Director William E. Colby apologized for the CIA. I wish to join with President Ford in expressing my deepest personal sympathy and hope that you and your family will also accept my sincere apologies on behalf of the Central Intelligence Agency for the suffering you and your family have endured as a result of the untimely loss of your husband. In 1953, the uniform reaction of the employees of the agency to this disclosure has been dismay and regret that this could have occurred. I can't find no explanation for why you were not fully informed of the circumstances at the time and apologize equally for that omission. On October 12, 1976, President Ford signed legislation providing $750,000 recompense to the survivors of Dr. Olson and, after stating that the LSD would appear to have been the proximate cause of his death, went on. The approval of this bill underscores the basic principle that an individual citizen of this nation should be protected from unreasonable transgressions into his personal activities. There should be no doubt that my administration is opposed to the use of drugs, chemicals, or other substances without the prior knowledge and consent of the individual affected. At the request of the family of Dr. Olson, I take this opportunity to highlight this continuing policy. These contrite apologies from the highest level of our government made it clear that there had once been a decision that those injured in MKULTRA should be compensated. In addition, we now had obtained additional CIA documents demonstrating that, in the wake of the Olson death, CIA Director Dulles ordered that the review board be created to oversee and control TSS research and experiments. But the Dulles order was not carried out and no other steps were taken to ensure that there would be no repetition of the reckless and negligent conduct in the Olson death. Despite the Dulles order, Cutler and Lashbrook were left in charge of MKULTRA without even a reprimand. 31 In that capacity they approved the funds for brainwashing experiments performed by Dr. Cameron without the review and oversight of the Special Review Board ordered by Director Dulles and with the same recklessness they had exhibited in the Olson death. 2. New evidence of CIA negligence in its relation to Cameron. One of Cutler and Lashbrook's assistants was John Gitter, who learned of the work of Dr. Cameron in the brainwashing field by reading an article appearing in the American Journal of Psychiatry in January of 1956. In preparing our case, we consulted Dr. Robert J. Lifton, an internationally recognized expert on brainwashing who had conducted one of the seminal studies of Chinese communist practices during the Korean War. Dr. Lifton agreed to review that 1956 Cameron article and testified in court concerning the similarities between Cameron's techniques and the brainwashing procedures of the communist Chinese. In Lifton's expert opinion, the 1956 Cameron article described non-therapeutic and potentially dangerous techniques of repetition and isolation which were extensions of the totalistic methods of thought reform or brainwashing used in China and elsewhere. Lifton's view was subsequently corroborated by Cameron himself. In pre-1956 paper, Cameron had admitted that he conducted experiments with sleeplessness, disinhibiting agents and hypnosis in an attempt to exploit the method used to achieve the extraordinary political conversions which we have seen, particularly in the Iron Curtain countries. 32. We also asked Drs. Litton and Salzman to study the Cameron application and to be prepared to testify about their opinions of it. They were in complete agreement that the Cameron application showed on its face that CIA funds would be used to conduct extremely dangerous brainwashing experiments. As Dr. Litton concluded in his affidavit to the court, it is clear from the Cameron application itself that these procedures were experimental and deviated from standard and customary psychiatric therapies in use during the 1950s. The procedures in the Cameron application closely parallel the techniques of thought reform or brainwashing used in Chinese prisons and elsewhere, and represent the mechanized extension of those brainwashing methods. In short, the Cameron application was a transparent proposal to conduct experiments with thought reform or brainwashing procedures extrapolated from methods documented in the academic literature, and would have been seen as such by anyone reviewing it during the 1950s. Dr. Salzman likewise concluded in his affidavit, the Cameron application proposed a mind-control research project with no safeguards, no discussion of risks, dangers, and potential destructiveness. This is clearly outrageous, callous, insensitive, inhuman pursuit of an idea with no concern for possible destructive effects. It would be beyond any reasonable doubt that a foundation which supported such a project could not have had therapeutic expectations from the grant application. These conclusions were important parts of our case because the dangerous brainwashing experimentation described in Cameron's application clearly required some investigation of Cameron's competence and some provision for safeguards to protect the experimental subjects. As subsequent discovery confirmed, the CIA made no investigation of Cameron or his experimental procedures before making the grant, despite the obvious dangers to the human beings who were to be experimented upon with CIA funds. This is a prime example of the negligent failures to exercise reasonable care in the MKULTRA program that forms the basis for our second cause of action. We had found, moreover, dramatic evidence of the ease with which such an investigation could have been made. From 1947 through 1956, the CIA was in close touch with Dr. Owen Saland, chairman of the Canadian Defense Research Board during that time period. We contacted Dr. Saland, who provided us with an affidavit confirming that CIA had never bothered to contact him for his opinion about Cameron's competence, the departing and other experimental procedures used by Cameron, or whether it was appropriate to fund the experimental procedures used by Cameron. Dr. Saland agreed to appear and to testify concerning the fact that he had disapproved of Cameron's destructive experiments and made his views known. Again, his affidavit summarized these views. I knew of the experimental departing procedures used by Ewen Cameron. In the early 1950s, the wife of one of my associates sought medical treatment from Cameron at the Allen Memorial Institute. She was departed, and after seeing her I knew that this kind of work was something the Defense Research Board would have no part in. It was my view at the time, and continues to be, that Cameron was not possessed of the necessary sense of humanity to be regarded as a good doctor. My views of Cameron and the departing procedures were known to him, and I let it be known through Dr. Morton that I would not look favorably upon any application by Cameron to the Defense Research Board for psychiatric research. Cameron never applied for Defense Research Board grants to fund psychiatric research and would never have received such support had he applied. In addition, Dr. Saland was prepared to testify that there was a close relationship between himself and the CIA. During the 1950s, the United States Central Intelligence Agency had a resident representative of the United States Embassy in Ottawa who was publicly introduced as such. The CIA representative was liaison with the Royal Canadian Mounted Police and was free to attend Defense Research Board staff and committee meetings where defense research programs were discussed. Formal information exchanges with the CIA were made by the RCMP, and the CIA and Canada exchanged all research information of mutual interest during this time. The security clearances issued by the Canadian Defense Department during the 1950s were accepted by any United States agency working in Canada, including the Central Intelligence Agency. Dr. Saland also noted in his affidavit to the court that there was another knowledgeable expert, Dr. Donald O. who had been readily available to the CIA in 1956 and early 1957 when Cameron's application was being solicited and approved. Dr. Head, the highly respected chairman of the psychology department of McGill University during the 1950s, had worked closely with Canadian and U.S. Intelligence 33 and had an equally discrediting opinion of Cameron's brainwashing experiments. Unfortunately, Head had died before we could take his deposition. Because Dr. Head's testimony bore on Cameron's reputation, however, we were able to offer sworn statements of others about what Head had said without violating the hearsay rule. These statements relating to Head's opinions would not be offered as evidence of the truth of what Head had said, but as evidence that he had said it and would have warned the CIA to stay away from Cameron or at least make a full investigation of him and his work. In this way, we could avoid the potential bar of the hearsay rule to introduce the following sworn statement by Saland concerning Head's very low opinion of Cameron and his prudence in dealing with subjects. I know by my discussions both directly with Dr. Head and indirectly through Dr. Morton that during the 1950s, Dr. Head had a very low opinion of the departing and other experimental procedures used by Cameron and of Cameron's prudence in dealing with research subjects. Further evidence of Head's low opinion of Cameron's competence and prudence was provided to us by Ronald Bloomer, the documentary film writer and producer who interviewed Head shortly before his death. In their interview, Dr. Head stressed to Bloomer that Cameron was irresponsible and criminally stupid. Cameron's experiments were done without the patient's consent. Cameron was irresponsible, criminally stupid, in that there was no reason to expect that he would get any results from the experiments. Anyone with any appreciation of the complexity of the human mind would not expect that you could erase an adult mind and then add things back with this stupid psychic driving. He wanted to make a name for himself, so he threw his cap over the windmill. Cameron stuck to the conventional experiments and paper writing for most of his life, but then he wanted that breakthrough. That was Cameron's fatal flaw. He wasn't so much driven with wanting to know, he was driven with wanting to be important, to make that breakthrough that made him a bad scientist. He was criminally stupid. Bloomer summarized Head's statements about Cameron as completely escaping, with Dr. Head referring to Cameron and his methods several times as criminally stupid. Final corroboration of Head's view of Cameron came from J. Peter Tell, the research associate with the Center for National Security Studies, who had made an exhaustive review of the CIA's MKULTRA program. Peter Tell interviewed Head in the summer of 1978 and provided us with an affidavit based on his detailed notes of that interview. Dr. Head, look, Cameron was no good as a researcher. He was terrible. He did not have the faintest notion of how to go about doing experiments or doing research. But he thought he did. Dr. Head, he was eminent on the basis of politics, psychiatric politics and university politics, but not on the basis of research. Dr. Head, well, that was an awful set of ideas that Cameron was working with. It had no intellectual demand, it called for no intellectual respect. If you actually look at what he was doing, and what he wrote, his proposals, it would make you laugh. That is what I meant being awful. If I had a graduate student who talked like that, I'd throw him out. If Head felt this strongly in talking to strangers, we argued, it is clear what he would have said to the CIA if they had not treated this matter too casually to warrant interviewing him or anyone else. Indeed, the CIA formally admitted in court papers that, despite its close ties with Dr. Head, the agency never bothered to ask him about Cameron. Moreover, since Saland and Head were both working with the CIA in the 1950s, there can be no suggestion of secrecy reasons for not inquiring of them, only reckless and negligent indifference to the safety of the subjects of experimentation. In addition, we developed evidence that even casual inquiries of those in Montreal who knew of the controversial experiments being performed by Cameron would have revealed to the CIA the risks of injury and averted the tragic events subsidized by that agency. Dr. Paul E. Termansen, a Vancouver psychiatrist who was treating Plaintif Logie, had been at McGill in the early 1960s and provided us with a sworn statement that during his time at McGill there had been considerable controversy about Cameron's experimental activities, which were promptly terminated by his successor Robert A. Klebhorn. Dr. Saland also confirmed that during the 1950s, there was considerable controversy in the Montreal and Canadian psychiatric and academic communities about the departing and other experimental procedures used by Cameron at the Allen Memorial Institute. As these affidavits made clear, there was tremendous controversy surrounding Cameron and the experiments he performed, which would have alerted the CIA to the dangers of funding human experimentation at Allen Memorial. The CIA's lack of care and failing to make any investigation whatever of Cameron was equaled only by its callous failure to ensure safety and consent of the subjects, victims of the subsidized experiments. 3. New evidence of CIA negligence in failing to ensure safety and consent of subjects. From documentary discovery, we had found no provision at the time of the approval of the grant or later to ensure that the experimentation was safe or that only consenting volunteers were used as experimental subjects. We confirmed that no precautions of any sort had been taken through the deposition testimony of John Gitter, the CIA project monitor for the Montreal Experiments, Sidney Gottlieb, the director for the MKULTRA program and Gitter's supervisor, and Robert Lashbrook, Gottlieb's deputy. All three of these major actors in the funding of Cameron testified on deposition that the CIA took no steps whatsoever to ensure that experimental subjects would not be injured or that the CIA-funded experiments would be conducted in an ethical fashion. Gitter admitted that he never really thought very much about his Cameron's actions any time because I wasn't interested and that he was really not interested in his Cameron's patients. Gitter continued. Phew. You didn't have the slightest interest in Cameron. 8. That is absolutely true, sir. Asterisk, 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 asterisk. Q. You didn't feel responsibility to find out what Cameron did to the subjects of the CIA-funded experiments. 8. No, sir. Sidney Gottlieb likewise admitted that he had not evaluated the experimental protocols for the research Cameron would conduct with CIA funding, that he had not determined whether the procedures would injure experimental subjects, and that he didn't even know whether anyone at the CIA had done so. Robert Lashbrook was equally uninterested in the safety of the subjects of the experiments he was helping to fund. Q. Did you at any time make any suggestion on any projects on how to safeguard the experimentees? 8. It wasn't felt necessary really to go into a lot of detail as to exactly how they were handling the subjects. In general, patients would be of low interest. Gottlieb, Lashbrook, and Gitter each also admitted that no effort was made to ensure that Cameron's patients would be told that they were undergoing experimental procedures. Gottlieb failed to determine whether Cameron was going to tell patients and their families that the experiments were new and untested and that other accepted therapeutic procedures were available for mental illness, and he had no recollection of instructing Gitter concerning the CIA-funded experiments. Gitter admitted that patients in a psychiatric hospital often exercise impaired judgment and that it was particularly important that they be told that they were participating in experiments. Yet he too felt no obligation to protect the psychiatric patients who would be used in a Montreal experiments and, indeed, failed even to instruct Colonel Monroe to obtain reports on the condition of those patients after the experimental procedures. In short, Gottlieb's deposition testimony was Q. It is correct, is it not, that Cameron had complete discretion as to what he would tell the patients in the experiments that were funded by the CIA? Witness and counsel confirm. 8. That is correct. At his deposition, Gitter, too, displayed a total lack of interest in the subjects of a Montreal experiments. Q. Did you ever make a check on whether Dr. Cameron was doing it unwittingly? 8. I certainly did not, because I had absolutely no interest in that area, as far as he was concerned. Q. You weren't interested a Canadian citizen might be unwittingly given LSD, with USA money? 8. I was not. Lashbrook was equally unconcerned. Q. Did you ever at any time hear a conversation at the CIA concerning the question whether the persons who were experimented on must be told that they were being experimented on? 8. Not that I recall. Indeed, Lashbrook admitted he had not heard one single thing about Cameron's operation after he, Lashbrook, directed the sending of the money to them. After CIA funds were forwarded to Cameron, the CIA officers failed to supervise Cameron's experimentation in any way. Gitter admitted that he never saw a report from Cameron, that he never visited Cameron in Montreal, and that he never asked Monroe to report to him on what Cameron was doing. Despite his ignorance concerning Cameron's CIA-funded experiments, Gitter nonetheless certified as project monitor that Cameron's progress was satisfactory on the basis that we just were given word that they were having no problems. Gottlieb admitted that he did not know anything about the experiments Cameron performed with CIA funds, that he didn't know what experimental subjects were told about the CIA-funded research at McGill, and that he had no recollection of anyone at the CIA telling him the details about Cameron's experiments with intensive electroshock, LSD, sensory deprivation, departing, sighted driving, or prolonged drug-induced sleep. The significance of these admissions by the key CIA officers involved in the Montreal experiments was driven home by the affidavit of David J. Rothman, Ph.D. The eminent social historian at Columbia University's College of Physicians and Surgeons. Dr. Rothman was prepared to provide testimony at trial detailing the history of consent from the Hippocratic Oath through the Nuremberg Code and its aftermath. As detailed in his affidavit to the court, Dr. Rothman's conclusions left no doubt that the conduct of Gottlieb, Flashbrook, Gitter and, ultimately Cameron, was unethical. During the 1950s there was a recognized obligation on the part of entities financing, sponsoring or conducting medical experimentation to adopt ethical standards reflecting the principles set out in the Nuremberg Code, particularly the informed consent requirement, and to make inquiry and to ascertain the competence and prudence in dealing with research subjects of those conducting medical experimentation on their behalf. By the 1950s it was clearly irresponsible for a physician to conduct experiments upon patients without obtaining their voluntary consent to be research subjects. As the deposition testimony of Gottlieb, Flashbrook, and Gitter made clear, these ethical principles were mocked by the CIA's conduct in the MKULTRA program, and the agency's subsidies to the experimentation performed on our clients.